Hey out there, legal warriors. Did you ever wonder if you have a car accident with public property, a guardrail, a telephone pole, something like that? Is that a crime? And what should you do about that to make sure you're not charged with a crime? If you're interested in the state of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. So if you find this video interesting, please like and please subscribe. More people get to see it and get the help they need. Now I'm just going to jump right into it. You know, I was getting my hair cut 2 days ago, and I was telling my hair cutter, hey, I've got all these videos out, and I could use some more ideas. And my hair cutter told me, hey, Lance, did you know that if you run into a guardrail, you could get charged with hit and run? Talk about that. And of course I said, yeah, I do know that. I've seen that case several times and I really disagree with it. So therefore I thought I would put out a video here to help explain to people what to do if your vehicle runs into some type of public property, a guardrail, telephone pole, something like that. So there is a crime in this state. Let's ignore reckless driving, but the main crime we think about would be hit and run property, RCW 46.52.010. Hit and run property is usually thought of as, hey, I hit a parked car or I hit somebody's mailbox. We've run into some private owner's property, but not somebody in a vehicle, something like that. In those cases, what do we think? Well, it's pretty clear I need to put a note on that car, or I need to reach out to the owner of the mailbox to get it fixed because I caused that problem. But what we don't think about, and I really never thought about it until I first saw the cases come into my office, is what if we just run into a guardrail? I mean, isn't the guardrail there to guard us from going off the street, isn't it? Or a cliff or something? Isn't it sort of intended? The design to purpose is to absorb an impact from a vehicle in a dangerous situation. So if I ran into a guardrail, I actually myself, I wouldn't think anything about it, right? That's what it's there for. I wouldn't think, oh, I better go track down the owner of the guardrail. Or if I ran into a telephone pole, maybe a little different. It's not meant for that reason, it's meant to hold wires. So I've actually had crimes in my office where somebody ran into a guardrail and was such a big collision that their license plate fell off. Well, the cops found the license plate and went and found the person and then charged them for hit and run for not, leaving a note on the guardrail, I guess, at 2 a.m. Well, if we take a close look at the statute, what we can see is that it says if a vehicle runs into property on or along a highway, just think that as a road, not an actual highway, and there's an accident that causes damage to that property that's on or along the highway road, then that person who causes the accident or is even involved in the accident actually needs to figure out who the owner of the property is and contact them, or who's in control of the property, it says, and contact them and give them their information, their name, address, etc. And that's pretty hard to do at midnight or 3 a.m. or 7 p.m. or whenever it is we had this accident. So the statute also says we're supposed to report the accident like we would other accidents, and that can get pretty murky in the law about what we're supposed to report or not. So if in that situation with that particular client, they got charged with hit and run property, which is a simple misdemeanor, 90 days in jail and $1,000 fine max. So if you're in that situation where you run into a guardrail and there's damage to the guardrail, what the law says we're supposed to do is we're supposed to call the police, I guess, right? And report the accident. I don't know that I would be able to figure out who is in charge of the guardrail, right? And maybe some public works department of the city or the county that you're in. So if you happen to run into a guardrail that has damage to the guardrail, if we want to avoid getting charged with hit and run property, we're supposed to call and report it to the police. Now, I wouldn't advise that if we've been drinking and this is a DUI situation. At that point, we might want to just take our chances. But basically, that's what the law says you're supposed to do. What about some other type of property? What if the telephone pole that I mentioned earlier, what do we do there? Well, there it's a little bit easier to figure out. that we should do something, right? If we damage a telephone pole, God forbid the telephone pole falls down, and we're going to hopefully want to remain at the scene and contact the police so you don't get charged with hit and run. Again, if it's a DUI situation, you're going to figure out what you want to do about that. Can't give you legal advice here. But for a telephone pole, you're also going to want to contact the authorities. There are other parts of public property. Yeah, I've seen a case where someone ran over wet cement that the public was the workers were just putting down, right? And ran over wet cement and didn't even know they had run over wet cement, but yet because they didn't stop and report the damage to that public property, the wet cement, they get charged with hit and run property. So there's a lot of ways that anyone can get in trouble with the law. So what we want to do to avoid it is if we have any damage to public property, we probably want to call the police. Maybe not then and there at that second. You might be able to get home and do it, right? There's some question about the timing. It's a little bit different than hit and run attended, where it's immediately stop and stay. But it's all subject to interpretation by law enforcement. How do we defend these situations? Well, luckily, there's a statute called compromise of a misdemeanor. Compromise of a misdemeanor is a statute that basically says if we pay for the damages to some non-felony crime, and then if the owner of the property says they're satisfied with our payment, usually in writing, then we can petition the court to dismiss the case. And it can't be done in every case, but in many hit and run property cases, if we can get the damage paid, if maybe our insurance company will pay the damage, stuff like that, then your attorney may be able to get some city official to agree, or county official, or whoever is responsible for this property, to agree any damages have been paid. And then hopefully your good record with your good attorney can work together to try to get you a dismissal under that statute. I think it's RCW 10.22.010, if I remember. So I hope you found that useful. Really weird case when this happens, and I thank my hairdresser for giving me the suggestion. And if you have any suggestions, please put them in the comments. I've done 300 plus videos, and I'm always looking for more things that you want to know about, at least if I know something about it. If you have this issue, feel free to reach out to us. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.